MetLife long-term disability denials, when you're finally denied by them, the only option you have at that point in time, assuming you have a employer-provided policy, is to file an appeal. And that appeal is can be a complicated, but also a super important documentation and time in a claim where you only get one shot to do it right. But most people have no idea what I'm even saying when I talk about why you only have one shot to do it right and why you should even have a lawyer to assist you with that. Now, the person watching this video probably went on YouTube, found our channel, went on Google and said MetLife Disability Appeal Help, MetLife Disability Appeal Lawyer, and they stumbled upon us. So what I want to do here is I want to educate them as to why they should have help in doing this appeal and also what to expect in this appeal. So Frank, start with why it's so important to present a super strong appeal against a MetLife denial.
I think first and foremost, the insurance company and the claim examiner is going to call the insured when they deny the claim. Hi, Mr. Claimant. Sorry, we denied your claim. The problem for the insured is the next line is, but you can appeal. It's simple. All you need to do is write us the one-liner and say you dispute our wrongful decision. And the insured believes that they can come to me at the end of the day, or you or Rachel, and we can fix what they didn't add, what they forgot to include, what testing they might have had but thought, well, later on the lawyer can take care of that. You mentioned one shot. For insureds, first of all, pick spectacular counsel. Counsel that can afford to do a terrific appeal for you, because you only have one chance. This is your one shot. If, for instance, you did the one-liner, please overturn my wrongful denial. The insurance company upheld the denial, and the next day you had a dramatic heart attack. Could you get the heart attack in? No. The record's closed. So you've got to do all your testing, all your interviewing, all your objective functional capacity evaluations, MRI, CT, X-rays, get all the prescriptions in, the vocational information. If there's financial issues about you working part-time, all those things are super important. And you need the administrative record, the full record from the time you applied for the coverage until the time that they wrongfully denied your benefits. You've got to get the administrative record. Then you can have that conversation with the insured about the strengths and weaknesses and what a great law firm can do to try and get them their benefits.
I want to be repetitive because people hear, the first time you just said it, well, what if you had a heart attack the day after they made a decision on an appeal? Under no set of circumstances whatsoever, once MetLife makes their final decision, no other evidence is coming in. It's so much so that if they make a decision to deny you, the next day you're driving to the grocery store, you get hit by a bus and you're hospitalized, nobody ever knows about it. MetLife never considers it. The court never hears about it. It's as if it never happened. So what does that mean? From the period, the 180 days that they give you to do that appeal, you better get every single piece of evidence in there that you want. And Rachel, that leads me to the strategies that we put in place, the special sauce, the reason that you hire a lawyer. What is it that we're doing to put together this rock solid appeal in order to convince MetLife to say, hey, you got it wrong? And it is a process. And before I tee you off down this road that you're about to go on, the one nice thing about ERISA that I do like and I do believe in, and I believe that they do legitimately do this the right way, they are supposed to create this firewall or Chinese wall, for whatever that name is, to say that the next person who's going to get this file is going to have absolutely nothing to do with the first person, the doctors, anybody who touched that file the first time cannot even so much as look at this file the second time. Now, you have to believe, because it would be fraud if they didn't do it that way, but what does that mean? You are truly getting a new bite of the apple to present your evidence. So where do you go with that, Rachel, in order to really put together a five-star appeal for your clients?
Well, the first thing we do, and Frank mentions the administrative record, the first thing we do is we request the administrative record from MetLife because everything they've done from the second you've filed your claim forms with them to the second they denied your claim is in that claim file. That would be the peer reviews when they hire their doctors to do their paper reviews. Their peer review reports are all included in the claim file. Everything's in there. So we have to review those, and they could be anywhere from 500 pages to 5,000 pages. It depends on how long you've been on claim and how many medical records you have, but we review it all so that we know the basis of why they denied these claims. And we've been doing this for so long. We know what MetLife's looking for. We know what it takes to get these appeals overturned. So we review the claim file, and then we determine after that what needs to be done to prove all of the things that MetLife claims in the denial letter were not sufficient to keep you on claim.
And this record, just so people know, if someone has never been on claim, it might be a couple hundred pages. If they've been on claim for years and years, like we've seen, or they get denied after a change of definition or whatever, it could be thousands of pages that has to be gone through. And so imagine a claimant gets this and goes, what is this? And like you said, Rach, we know exactly where to go in that claim file. Also, all of any notes they did, every single thing is there, which is a nice thing I like about ERISA, because in the world of lawsuits where people think I got to do discovery and then I got to motions to compel them to give us everything, and are they hiding anything? No. Under the law, they got to give you everything. So that's nice that you have everything they relied upon, and if it's not there, they can't bring it in at any other time.
Absolutely.
All right, so you eat up that claim file, and then what?
And then we determine what do we need from our claimant to prove that they can no longer they still cannot sit at a desk 40 hours a week, do a job, sit at a computer. Let's assume that it's a sedentary job that they're trying to prove that they cannot do. So we will work with their doctors hand in hand. So we make sure that, first of all, they're treating on a regular basis and that their doctors are documenting their restrictions and limitations. The biggest problem we see is that doctors are not documenting when they can't sit for long periods, can't stand for long periods. If they have a severe back issue, are they doing updated MRIs and CT scans? Is there objective proof that their condition not only has not gotten better, but maybe has gotten worse? We work with the doctors to help them. We have forms that we actually prepare, attending physician statements that are geared specifically towards each client's disabilities. So if there's things that they specifically can't do, we prepare a questionnaire. Sometimes it's 2 pages, 3 pages. We have the clients take them to their doctors, and we will sit on the phone with the doctors, help them fill them out if necessary, and make sure that these doctors are being very clear about what their patients can't do, and even more important is what's in that medical record. So I tell my clients all the time, your doctor can say anything he wants, but if he's not documenting it regularly in the medical record, the insurance company is basically going to ignore it because they rely on what's in those records.
And I love that, that's one of the best things we do are these custom attending physician statements, other than, the attending physician statements that all of the claimants have seen, because you got to do one when you submit a claim. You have to do one every month, every 3 months, 6 months, once a year, once you're on claim. They have 1 or 2 lines on them. Right. I mean, they're meant to set the claimant up for failure. They're meant to put the doctor in a position where he's not saying anything. And then if the doctor just checks 1 or 2 things, they go, well, your doctor's, and then the doctor says, see my records. But then the records are usually weak. Unfortunately, that's the norm because doctors don't document medical records for insurance companies. They despise insurance companies, most of them. This is not something I'm making up. They rip them off. I mean, they beat them down on what their fees are. These doctors have hundreds of thousands of dollars in loans, working hard to save people's lives. And every month they get something from the insurance company. Guess what? Your reimbursement went down 10%. But all the other materials went up 10 or 15%. So insurance companies are making more money. The doctors are getting beat up. They can spend less time with the claimants. And they just don't document a lot of things in the file. So the medical records become weak. But you work with the doctors through those custom attending physicians. We build absolutely tremendously strong medical evidence so that when MetLife gets this, they go, okay, I get it. The person has this diagnosis, but I also need to see that they have these restrictions and limitations, and how does that apply to their occupation? And I know, Frank, you believe, and you always work super hard on what's the occupation, because that's an element of disability. Talk about how that's important, how you prove to the carrier and tie it all together to say, not only does this person have these restrictions and limitations, but here's the occupation, MetLife, that you screwed up, that they can't do. How do you get there?
So first you have to look at the policy and decide, is it national economy? What does that mean? That means that we're going to look at the work as it's done in the national economy. If they do it a certain way in Mississippi, they've got to do it the same way in New York. They got to do it the same way in Florida, national economy. Some of the Met policies have a local economy definition. So you might do the work differently in your local economy. Say you're a offshore longshoreman and they did it differently in the Atlantic Ocean versus the Pacific Ocean when they're drilling for oil. We got to look at the policy first to see whether it's national economy or whether it's local economy. Then we look at a job description that describes the specific duties that the insured has to do. Are they bending, lifting, stooping, pushing, pulling, carrying, reaching, all the kinds of things that an occupation may demand? And then we're looking at the physical demands, sedentary, medium, light, heavy, to determine, are they lifting? Are they sitting? Most of the doctors, believe it or not, don't know the difference between sedentary demand and light.
Nobody
They
does.
don't know the difference between how long you sit, and the carrier confuses them and says, Greg, come on, Greg, we're going to let you alternate, sit, stand, and stoop. So gee whiz, you don't have to stand for 2 hours. You can stand for 15 minutes and take a break. It sounds real easy. So I like to look at the occupation, the demands, and make sure the doctor understands, because they're going to catch him without the file. Metlife is perfect at contacting the doctor during the business day to ask him a quick question about their insured. Hey, by the way, we're going to give him a sedentary job. Are you with that, doctor? Doesn't have the file, doesn't have a clue about sedentary demands, and he's caught off guard. May willy-nilly sign off on letting the insured do a demand like that.
Or the nurse or
Yeah.
the PA or the assistant in the office just fills out the form because the doctor goes, okay, looks good.
Yeah. We spoke to Joanne. Who the heck is Joanne? That's the reason that you have customized forms that we do for our insurance.
Talk about how you could work with a vocational expert to help clarify the occupation, because it bothers me so much. You guys see this all the time in almost every Met denial letter. Your occupation is sedentary. They make it to the point, Frank, where I could bring in some, and I don't want to be rude, but I could bring someone in here who's basically, significant cognitive difficulties, right? But that person could sit in that chair for 6 hours. And most of the Metlife denials on a sedentary job go, you could sit in a chair for 6 hours. What job application, Frank, says, the requirements of this job position posted, the requirements of this job are you must be able to sit in a chair for 6 out of the 8 hours of the day and nothing else?
Well, they assume the insured's a potted plant. Or a baby that's 0 to 6 months that you put in a carrier, and they'll sit there but there are problems with sitting for that long a time. So I love hiring a vocational expert. They're terrific at picking the salt out of the pepper in terms of the physical demands, the cognitive demands, and those are just as important. Just because I can sit or alternate sit-stand doesn't mean that I've got sustained attention. It doesn't mean that I've got consistency in terms of my recollection. It doesn't mean I can keep pace, and it doesn't mean that I'm not cognitively impaired, either from pain as a distractor or from the medication I'm taking to deal with my restrictions and limitations. So I love a vocational expert who can tease out the nuances of the occupation and then marry the medicine and the restrictions and limitations and the prescriptions to the demands of the work to say vocationally, I'm an expert. I've looked at thousands of these. Poor Greg cannot do the work he was doing at the time.
But and Rachel, you know this as well, Metlife usually, when they send it out to their doctors, they don't even know the occupation of the person. So I'm looking at this painting behind you of the airplane, and I'm thinking about all the pilots that we've represented. And the pilot who's flying the plane with passengers on there who says, my neck hurts, my back hurts, I'm uncomfortable. Yeah, I can get up and take a break, but then I get fatigued, I can't focus. How does a pilot have the opportunity or the time to make any mistake and feel uncomfortable flying a plane? But Metlife reviews it and goes, no, your job is sedentary because you don't have to lift anything on the plane, and you could sit for 6 hours so you can go do your job. It doesn't matter. You have to think, you got to put in all of wherever you're going, all your coordinates, you got to listen to air traffic control, you got to be available in emergency, fly the plane if autopilot doesn't work, but you could sit.
Look, we've We've looked at hundreds and thousands of those kinds of cases, and we're a firm that utilizes vocational experts. We also do neuropsych testing to be able to objectively test someone's cognitive ability to see whether they can sustain their attention in a 5-hour test. So at the end of it, you've got objective evidence to be able to give to the treating doctor to say, just because he can sit doesn't mean it's safe for you to let him pilot a plane.
So there's tons of different avenues to go, and just bringing up, we talk about neck or back, or we talk about whether it's depression or anxiety or whatever, and there's cognitive aspects to every claim. No matter what is, we've seen every single occupation. We've seen every single medical condition. We've seen every single definition of disability that Metlife can throw at a person. So with that, claimants have that great advantage. Plus all of our lawyers that handle this nationwide, with more than 14 lawyers doing this, we talk all the time. We see every single technique. We know the experts all over the place. So that's really fantastic for the claimants to be able to be in the best position possible to use our team to present their claim, so that goal for me is Metlife gets this, and no reasonable human could look at this and be like, this person is not disabled. They have to conclude this person's disabled. They can't agree anymore, and that's why we win so many of these claims. So
the other reason we win so many is because we see these claims in real time. We're seeing thousands of denials a month all across the country. So if Met decides a new denial strategy is working in Mississippi, we're seeing it within 2 minutes of them employing that new strategy. We can get in quickly. Nobody's seen more, evaluated more, resolved more, litigated more than we have. So seeing the country in real time gives us a real significant advantage to get in early and know what the insured is going to face.
That's a great point. Well, the best part for the claimants is that we never charge any fees or costs unless we make a recovery of money for the claimants. We're available all over the country to assist you, and we always provide initial free phone consultations. So we look forward to the opportunity to discuss your Metlife disability denial.